Right. Good afternoon, everybody. Thank you for joining us on a Saturday afternoon. Thank you for taking the time off to join us on this webinar on medical certification. So we're very honored today with us distinguished speakers and to talk on this topic, medical certifications and on duty, risk, legal pitfalls for family physicians. Before we start, just some housekeeping. I'm James, I'm your moderator for today. So to help us make the session enjoyable and worthwhile, please note that this session is for MME accreditation. Please remain connected throughout the webinar to be eligible for 2 MME points. Please use the Q&A function, which is found on the lower row, the right button on the lower row of your Zoom panel. Please do not use the chat function, and you can use the Q&A function to post your questions. The panelists will be answering the questions on the chat, on the Q&A along the way, but we will address some of these questions during the panel discussion and the QA session as well. And definitely at the end of the webinar, we will have a feedback. Please complete the feedback form. We will encourage you to do so, and your feedback is greatly appreciated and will help us to improve future MME programs and identify topics you would like us to cover. This is the program we have for today. So we'll have an opening by our president, Dr. Wong, and followed by the first two speakers. We'll first have Prof. Lawrence to speak on the ethical and professional considerations in MC issuance. And next we'll have Mr. Charles Lin, who will talk about the legal framework and medical legal responsibilities. We'll then have a break, and we'll come back to have the second part of the webinar. We'll have a case-based discussion led by Dr. Sarah from MPS, Medical Protection Society Singapore, and we'll finally end the webinar with a panel discussion and Q&A. So without further ado, let me invite President Dr. Wong to give the opening address. President, over to you.
Thank you very much, James. Good afternoon, everyone. And on behalf of the College of Family Physicians Singapore and the Medical Protection Society, I would like to warmly welcome all of you to this webinar, Medical Certification, Duties, Risks, and Legal Pitfalls for Family Physicians. Now, medical certification is one of the most common tasks performed by doctors in everyday practice. We often think of MCs for the purposes of sick leave, but we also do medical certification for fitness to work or to school, insurance examinations, and statutory medical examinations, such as for driving license renewal and 6-monthly domestic helper checkups. MCs for sick leave is the most common and the focus of this afternoon, but it should also be seen as part of a continuum of medical certifications. In all such instances, we as doctors are called upon to make professional judgments that have consequences for patients, employers, and society. What is unique about medical certification is that it represents a professional privilege entrusted exclusively to doctors. When we speak of a professional privilege, we don't mean a benefit or an entitlement. Rather, it refers to a special authority granted to a profession by society because of the trust placed in our knowledge, ethics, and ability to self-regulate. You see, medicine is built upon a social contract between the profession and the society. Society grants doctors powers and responsibilities that ordinary citizens do not possess. These include the authority to diagnose illness, prescribe medicines, access confidential information, certify illnesses and incapacity, and make judgments that may affect a person's employment, education, and insurance claims. For example, no other person other than a medical doctor has authority to pronounce death. And this is the focus of another webinar we have next weekend. But as they say, with such power comes great responsibility. Society expects doctors to place patients' interests above personal gain, exercise independent, unbiased professional judgment, act honestly and ethically, and remain accountable. Medical certification is perhaps one of the clearest examples of this social contract in action. When a doctor signs an MC, employers, schools, insurers, and even the government generally do not have to verify the diagnosis independently. They accept the MC because they trust that the doctor has conducted an appropriate clinical assessment and exercise honest professional judgment. So you can see that the whole process of medical certification is in essence about trust. It's about public trust vested in the medical profession. Every inappropriate MC issued weakens that trust. And the problem with that is that even if you are doing the right thing, but another doctor isn't, the other doctor's actions affects you. We therefore have to always remind ourselves that medical certification is far more than an administrative task, but an exercise of professional responsibility. As family physicians, we are expected to issue MCs only on proper medical grounds, following an adequate clinical assessment. Yet, we also know that certification is not always straightforward. Family physicians frequently encounter requests for backdated certificates, pressure from patients, uncertainty regarding fitness for duty, and situations where clinical judgment, ethical obligations, and legal considerations may come into tension. What appears to be a routine task can sometimes expose doctors to complaints, disciplinary proceedings, and even medical legal risk. It's therefore essential that we understand not only the clinical aspects of certification, but the ethical, professional, and legal principles that govern our practice. So that's why we're all here this afternoon. This evening's webinar provides an excellent opportunity for us to learn from experts in the field, reflect on common challenges, and strengthen our understanding of the responsibilities that accompany this important professional privilege. I'd like to thank our speakers and organizers for putting so much effort for this timely and highly relevant program. Thank you for joining us this afternoon, and I wish everyone a fruitful and engaging webinar. Back to you, James.
Thank you so much, President. So without further ado, I'd like to move on to the first speaker. Our first speaker is Dr. Lawrence, who is an accredited family medicine specialist, and he'll be talking to us on ethical and professional considerations in MCs. So just a little bit about Prof. So adjunct professor, associate professor Lawrence Ng is a specialist family physician with over 30 years of clinical experience, and is accredited by the Ministry of Health Singapore. He was awarded a fellowship of the College of Family Physicians Singapore in 2017, where he received formal training in medical ethics and professionalism. Dr. Ng previously served as a medical legal consultant with the Medical Protection Society Singapore, providing round-the-clock medical legal advice and support to thousands of doctors in Singapore. He has extensive experience as a medical expert witness and has provided expert opinions in cases before the Singapore Medical Council, acting on behalf of both prosecution and the defense. And a passionate educator, Prof. Wong is actively involved in teaching family medicine at the Duke NUS Medical School, and he has also authored numerous publications on medical ethics, professionalism, and medical legal issues in clinical practice. So without further delay, over to you, Prof.
Okay, thank you very much, James. I shall start my clock. I have 25 minutes, where I will end by 3:40. Can you see my slide?
Not yet.
Okay, can you see my slide now?
Still waiting for that.
Okay. All right. Can you see my screen?
Yes, we can.
Okay, thank you very much, James. Okay, today's talk is very important, and we're talking about MC, something that all of us do, whether we're specialists or we're GPs. And MC has been in the spotlight recently in the news, especially last year and the year before, about giving too much MCs, and the year before that was giving too little MCs. And actually, MC has been given even by the ancient Egyptians, and what we call paid sick leaves, paid sick leaves. So the content of my talk is into three parts, actually. What is MC, and what are the problems and burdens for GPs with MC, what I call the dark side of the moon. I present to you some research data that I found, Singapore and Malaysia, And then the main course for today is about the ECEG. What is our duty? And if we have time, then we'll talk about the worldwide GP's views on MCs, some possible solutions to the problems and burdens. So the the Singapore Medical Council Ethical Code and Ethical Guidelines is the main talk today, but it only tells you what you have to know. And today I will tell you what you need to know. So the MC in Singapore refers to what is known as a sickness certificate or the sick note. Some people call it sick listing. In Singapore, only medical practitioners can issue a medical certificate, and it carries certain obligation. Conversely, on the flip side of the coin, there's also a fit note, which has started in the UK in 2010, certifying fitness to return to work or to school, such as what we had during the pandemic. This is an important concept in occupational, social, and psychological medicine. So a question was asked recently, on what basis, what legal basis do we give MCs? And actually, it is actually enshrined in two laws in Singapore. One is the Employment Act in 1968, which says that the worker or employee can present himself for paid sick leave, only when certified by a GP. Then on the right-hand side, you can see that under the Medical Registration Act of 1997, or the MRA, in the yellow box, it says here a certificate, MC, can only be issued by a medical practitioner. So when you put these two together, the employer is not bound to accept MC that is not certified by a GP. So actually, it's in the law, the TCM cannot issue MC. So what is the MC? So the MC actually, what is the MC versus the fit note? So the fit note actually is something that's I want to talk a bit about, because we usually certify a person or a patient not fit to go to school or go to work after a certain time, but we seldom certify them back to work, to return to work. And this has been written up by Colonel Dr. Brian C. in the Annals of the Academy in 2017. And he says that actually keeping a patient away from work is detrimental. And it says in the right-hand side paragraph that anything more than 7 days actually is detrimental to the worker. So the MC is actually a legal document. And then it is also a piece of communication tool for you to communicate with, to be given to the patient, and the patient gives it to the employer, the human resource officer, the schools, can be armed forces, police, customs, immigration, insurance, and even to the courts. However, it is also confidential. So especially when we are dealing with third-party stakeholders who are non-medical. Now, the key point to make here is that while there are many stakeholders involved, your duty of care as the doctor treating the patient is to the patient. And what is this duty? This duty is to act in his best interests in the majority of cases, and public interest in some cases, such as in pandemic, for the prevention of harm to others. Now, the MC actually is a task that a lot of doctors find, to put it mildly, troublesome. We are vested with the authority to issue MC, and the MC has got normative, that means a set of rules, normative connotations, carries obligations and responsibility. However, this story has a far side of the moon, which we GPs know but seldom talk about. And the issue of MC, the problem of MC is the problem of gatekeeping, the gatekeeping role, which is fraught with daily difficulties for practitioners on the ground. And by the far side of the moon, I mean the side of the moon that is unseen from Earth. It is also called the dark side of the moon. And why is this so? Because doctors, patients, other stakeholders, we are imperfect people who live in a complex and imperfect world. Imperfect people using MC, which is also an imperfect system for paid sick leave. So there is also a human side to medicine, what we call the art of medicine. Now it's called medical humanities. So medicine is an art as much as it is a science. It is practiced with the mind, the cognitive, as well as the heart, the affective. And it often calls for judgment. And decisions may not always be based on hard logic, The diagnostic pathways and how decisions and judgments are arrived at are not always documented. And sometimes how these cases become indefensible when scrutinized because there's no documentation. And then the actions may be deemed as unjustifiable. Now, it is in the qualitative research that we find the problems in the art of medicine and MC issuance. And I give you here 6 references. They're all very good to read if you have the time. If you don't have the time, you just quickly listen to my talk and then we'll figure this out. So indeed, like Top Gun Maverick, Tom Cruise Maverick says, time is the biggest enemy in a medical consultation. We often teach the students some models for consultation, and one of them is called Pendleton. And for those of us who teach family medicine, we know there are 7 tasks in Pendleton. And nowadays, we also have to do what is called the HSG tasks, data submissions and all that. And MC is just one of those tasks competing for time in a busy clinic. It has been written in one of those articles I quoted that it is faster to acquiesce to a demand for MC than it is to work out the reasons why a patient should not be getting an MC, or why is he asking for an MC. So I repeat, in any clinic, time is the greatest enemy. So here you can see Pendleton's 1 to 7, the task, and actually task 1 has got 4 components, task 2 has got 2 more components. So where do you find the time? And this is the problem. Where do we find the time? The other aspect of MC, the dark side of MC, is that biomedicine, is this the only game in town? Now, it has been written in the ECEG that MC is only to be given on medical grounds. The question that is raised sometimes is MC confined to the biomedical grounds? As we know from Engel's biopsychosocial model, the triaxial model of illness, there's biological, there's social, and there's psychological. Can all these be grounds for MC as well? The other problem is MC is to be given arising from a doctor-patient relationship. This is written in the Singapore Medical Council, ECEG. It is also written in many other medical councils, including the Indian Medical Council, the Malaysian Medical Council. However, herein lies the conflict between the dual role of the healer or advocate in a trusting therapeutic relationship versus the assessor, the medical examiner, or the gatekeeper role. As written by the author Parvin. The gatekeeper role is often the source of the problems. Why? Because we begin with empathy in a patient-centered and respecting autonomy mode, and then at the end, we move to a paternalistic logic and judgment mode when issuing MCs. Almost paternalistic, So this is one reason why MCs are viewed by GPs as problematic, complicated, and burdensome. These are the words used in the literature. It can be an unwelcome daily challenge, often thankless and exhausting and leading to burnout. And I still remember a lot of us when we're choosing our specialty, one reason why many choose against family medicine is because it is seen that every day you have to deal with MCs. And there's some truth in this, I shall show you. So this is an article by Parvin that MC is more than just paperwork. And he says here, the problem is A versus A, the assessor role versus the advocate role. One moment you're the advocate, next moment you're the assessor. This conflict is the biggest issue in issuing MC. And so the other issue is that there's lack of support and training about the issuing of MCs. And I feel that it should start before a junior doctor starts his career. On a given day, most MCs are issued by primary care physicians, whether you're polyclinic doctors or your private GPs. And these MCs in primary care are usually issued for minor illnesses for short-term and not long-term disabilities. I will quote David Ng's article later. Most of the time, MCs by us are often all or none and not involving light duties. Sometimes they can, Serious illnesses requiring longer MCs are usually referred to hospitals or associates. I would like to draw this distinction because there are some sensational SMC cases that went to High Court for appeal, but these usually involve orthopedic injury cases, and they require MCs followed by light duties. And then there are a lot of questions regarding the light duties. So this is an excellent paper by David Ng and many other authors. And it is actually a cross-sectional study of 1 week of all polyclinics MCs issued in that 1 week. It does not include GPs, and that's the limitation of the study. So what's the data? The data shows that 22.6% of the attending patients got MCs. 22.6. That's almost 1/4. 1 in 4 patients seeing the polyclinic got MCs. And the average MC is 1.4 days. Okay, 1.4 days. So this is quite important to bear in mind. And these are the top 10. You look at the right side here. The right side has got the top 10 with MC or sickness certification. And out of the top 10, I draw your attention to the top 3, which is acute URTI, 30%, musculoskeletal, low back pain and all that, 12.5%. GI symptoms, gastritis, dyspepsia, 5.7%, headache, quite close, about 4.9%. And I'd like to point out that, do you notice that none of these are psychological in origin? None. Huh? And in overseas, the data is different. There is a huge proportion of MCs that will be issued for psychological illnesses. So I guess we are more biomedical here than in overseas, where they are also orientated towards psychological medicine. Okay, in Malaysia also, they have some studies, and the Malaysian author here wrote that physicians are reluctant to perform the role of gatekeeping, that means issuing MCs, and they find conflict. And in fact, they found that it's a lot of emotional strain. And then UK and European countries have actually found there's an abuse of MCs. And in fact, okay, I don't have time to put it into my slides. In Germany, they have just stopped this matter of self-certification. That means you can call up for the first 3 days of the working year, and you don't have to produce an MC. You just say that you're sick, you don't come in. And Germany has just abolished it. Yeah, no more self-certification in Germany. So I would like to present some guardrails for issuing of MC, how to stay out of trouble and know your duty. This is the main course that you have to listen to. And I would like to thank Prof. Devan from SMA and SGH, the Medical Humanities Institute, for providing some of these slides. So this is the most important slide. In fact, everyone should just screenshot this slide and then you can go home and read it, you know. But you must read every single point of B4 of this ECEG 2016, okay? You have to read every single word and know everything about this slide. Okay, I will go point by point. Now, the points that I will show in gray would be from the handbook on medical ethics. Later, I'll talk to you about it. So MCs must be issued only on proper medical grounds, arrive at good clinical assessment. By clinical assessment, they mean history taking and physical examination. It applies also to telemedicine, but of course, the physical examination is somewhat different, you know. MCs are issued either to promote the recovery of the patient or to protect third parties from possible harm, such as infectious disease, like, for example, during the pandemic, or if you got, even something as innocuous as head lice or hand, foot, and mouth, which is not innocuous, it can kill. But you must not take into consideration any other extraneous factors. So who pays for the consultation, whether it benefits the patient, such as NS man, or whether the employer's preference, whatever the preference may be. And recently in the news, the question of whether more MCs are being issued, is it caused by telemedicine? Or are there any other factors? So this is still a perennial question. And in fact, many of the MCs issued by telemedicine providers and the doctors involved are being referred for further investigation, such as by Singapore Medical Council. It's interesting to note that in Malaysia, the Malaysian Medical Council, as of 23rd September last year, has said that it has decided that the issuing of MC solely following a teleconsultation is not allowed. So Malaysia has banned it to the point that failure to comply may result in being subjected to disciplinary proceedings by MMC. Now, I have checked this with another doctor in Kuala Lumpur, and he confirmed that it's still in force. And actually, the MMA, the Malaysian Medical Association, endorsed this as late as November last year. So I believe it is still in force. So this is an example of the telemedicine portal being investigated. License was revoked for Mana Doctor Clinic for inappropriate practices, for short teleconsultation duration, for multiple MCs being issued for questionable and poor documentation. And the Ministry of Health will be auditing, monitoring other licensed providers of outpatient medical services via teleconsultation. And to the point that many circulars were issued by Ministry of Health on the issuing MCs via telemedicine. This is just about 2 years ago, so it's still ongoing. Okay, I read again the MOH circular. It says that integral to the issuance of an MC is that it must be made in the context of an existing patient-doctor relationship and is based on the duty of care that the doctor owes the patient arising from this patient-doctor relationship. The issuance of an MC under particular circumstances is not a standalone activity that can be divorced from, but is instead reflective of the duty and standard of care that the doctor must uphold in their management of patients. A mouthful of words, but basically it is part of the duty that you provide to the patient. Feedback from the employers and other government agencies regarding excessive issuing MC, particularly in the context of teleconsultation. The next point you must note is MC issued solely based on the patient's self-reported reasons that they had input into the teleconsultation platform without proper assessment by a doctor to determine if there were indeed any other underlying health conditions which warranted the MC. So the issues of whether or not self-reported reasons are good enough, and then non-medical reasons, so MCs that were issued for people who want to skip work at school or school but they were not sick, and abuse of medical leave privileges. Repeatedly, MCs were issued without referring them for physical consultations for further assessment. B4.1, MCs must be issued to patients only on proper medical grounds, arrive at good clinical assessment. Okay, the one in gray is not in the ECG, but it's in the Handbook of Medical Ethics. Unless there are clinical reasons, well, patients who consult you should only be given MCs for attendance. That means certificates of attendance, not MCs. Using sick leave to attend a doctor's appointment. I think this one will cover in the Q&A. I don't have the time. MOM is quite supportive, but sometimes we are a bit harsh on ourselves. The B41 says that it is inappropriate to issue MCs of too short a duration, too short for recovery, and yet there's also issue of issuing MC too long, Okay. B42, MCs ought to be given directly to the patients and no other parties. Then it's for the patient to then hand it over to the human resource or the boss. MCs must be written objectively, accurately, in good faith, and cover the appropriate duration. And where relevant, accurate account of the patient's limitations during the period covered. Okay, attendance of court, I will leave it to Charles. This is about attendance to fitness to attend court or unfitness to attend court. Okay, if you are certifying the patient's fit to return to work, you must certify fit to work, but with limitations on the level of activity. To the best of ability, you need to be assured that the patient's work conditions allow this, and duties appropriate to limitations are in fact available. This covers the question of light duties. So if you issue light duties, you must ensure that there are light duties for the patient to do back at work. So you can ask the patient and then document down that you ask the patient, or you can call the employer or the supervisor and ask them what appropriate light duty is available. If light duty is not available, the appropriate light duty is not available, you should then order complete rest. That means give them the MC. Post-date the MC, no, you cannot post-date or backdate the date of issue. The date of issue must be on the day of the consultation or the treatment. But if you want to start the coverage of the MC before the date of issue, that means before the patient saw you, you can, but it must be consistent with the clinical presentation or the illness. So then you must document it down, you know. So when it comes to the date of issue, do not post date, do not backdate. Okay. Then any MC issued by another doctor, you must not amend it. Yeah. You can reassess the patient, and then you can issue a fresh MC. So it also helpful if you can discuss the case with the doctor who issued the original MC, and for you to understand their rationale for issuing the MC. So you must not amend the particulars on the MC. And if you disagree with the MC issued by another doctor, you can issue a fresh MC. But it's only after you assess the patient yourself to determine that this is justified. Diagnosis must not be stated on the MC unless you have the patient's consent. Okay, diagnosis must not be stated on the MC. Don't write your diagnosis on the MC. As with all third-party disclosures, the patient needs to consent to the disclosure, but sometimes employers will contact the doctors to try to find out more about the patient's condition. And unless you have the patient's consent, such information cannot be revealed. So whether you want to pick up the telephone and speak to the human resource officer, that's up to you. How confident you are of not breaching the confidentiality. And you must sign the MC personally, okay? Because you are personally responsible for it. This is a new healthcare regulation under HACSA in 2024, which then state that the name of the medical practitioner or the dentist must be given, and the registration number, so the MCR number. And if this applies also to the electronic MCs, there's one portal called mc.gov.sg. This is to ensure that there is no fraudulent issuing of MCs. Hospitalization MC, now this is a big one. Suffice to say that at the moment, only specialists who can admit a patient into any facility are able to write such MC. So for most of us GPs, we are not allowed to write in the hospitalization MC. Pregnant women, if they have medical indications that require hospitalization, regardless of whether they are warded or not. Patients undergoing chemo or radiation therapy will require rest but not warded. Post-day surgery, medical inpatient care at home, quarantine orders, this can be issued hospitalization MC. So this is coming to my last slide. So take the issuing MCs very seriously. MCs are to be issued on proper medical grounds, arrived through good clinical assessment. How you deal with inappropriate requests, like we all know, there are certain steps, but I won't cover it today. And then the issue of light duty, and then never post that or bad date, the date of issue of MC, and that any fraudulent MC is always treated very seriously. So this is introduced. The next slides will all be on problems and difficulties, but I will not cover it for lack of time. I hand you over to the chairman. Thank you.
Thank you very much, Prof. Lawrence, for sharing with us and sharing us of the insights regarding the difficulties that GPs face on the ground with regards to issuance of MC and also the professional and ethical obligations that doctors have when it comes to issuing MC. I see some questions being posted on the Q&A. Please continue to post them, and we'll take them. So thank you very much, everyone. So we'd like to move on to the next speaker. We have with us Mr. Charles Lin, who's the Managing Director of Charles Lin LLC, to speak to us on the next topic, which is regarding medical certification, legal framework, and medical legal responsibilities. So just a bit about Mr. Charles. Mr. Charles Lin obtained his Bachelor of Law honours from the University of Buckingham and was called to the English Bar in 1989 as a member of the Middle Temple. He's an advocate and solicitor of the Supreme Court of Singapore and also serves as Commissioner for Oaths and Notary Public. Mr. Lin commenced legal practice in 1989 and joined a leading medical, legal, and dental defense firm in 2011. And since 2017, he has been the director of Charles Lin LLC. With more than 35 years of experience, Mr. Lin is widely recognized for his medical, dental, legal, and healthcare law practice, representing doctors, dentists, healthcare institutions, and medical professionals in disciplinary, regulatory negligence, and professional misconduct matters before the courts, the Singapore Medical Council, and the Singapore Dental Council. He also serves on the Law Society of the Singapore Advisory Panel for Medical Law Reform and remains actively involved in pro bono and humanitarian work, including medical mission trips to Myanmar. So we're very privileged to have Mr. Charles with us to share with us on the next talk. Charles, over to you.
Thank you, James. You're most kind. Thank you, everyone, for taking time off this Saturday afternoon to attend this very interesting webinar. I will first start with the power to issue medical certificates. Next slide, please. Within the Medical Registration Act, Part 3 is entitled Privileges of Medical Practitioners. We can say that the power to issue medical certificates sits within this part. Section 13 sets the basic rule. A person must not practice medicine or do any act as a medical practitioner unless registered under the Act and holding a valid practicing certificate. Section 15 is headed Medical Certificates. This is the specific provisions dealing with the MCs. It recognizes the legal validity of medical certificates signed by registered medical practitioners. While it does not itself confer a standalone power to issue MCs, it provides that where a written law requires a certificate from a duly qualified medical practitioner, the certificate is valid only if signed by a registered medical practitioner with a valid practicing certificate. Now, Section 16 clarifies that a certificate is to be signed by a legally qualified medical practitioner or duly qualified medical practitioner. This expression means a person registered under the MRA with a valid practicing certificate. This is the key linking clause. It is what makes an MC signed by a SMC registered doctor legally recognized across all the other legislation that reference sick leave certificates, sick leave fitness certificates. All in all, registration as a doctor alone isn't enough. The doctor also needs an annual renewed practicing certificate issued by the SMC before they can practice, including issuing medical certificates. In short, the legal power comes from the MRA. The rules on how to exercise the power responsibly comes from the SMC Ethical Code and Ethical Guidelines. Now, what are the considerations? Next, please. What are the considerations for a medical practitioner when issuing a medical certificate? Lawrence has cited Guideline B4. A medical certificate must be based on clinical decision, and you must must be based on proper medical grounds, arrived through good clinical assessment. Now, before I go on the common allegations, I would like to tell you what the SMC requires in terms of certificate medical certificate. What I say now is actually an extract from an actual SMC case on telemedicine, but it would apply equally to general practitioners. Now, what does the SMC expects a medical practitioner to do before he issues medical certificate? You must prove that you have taken time to assess the patient visually to determine if the patient appeared drowsy, disoriented, or toxic. You must obtain a detailed history for the ailments complained of during the consultation. You must pose relevant questions to check if the patient was feeling weak or numbness in any area of their body. If their vision is blurred, if there are any fevers or rashes, and if they were experiencing any giddiness or loss of consciousness prior to the consultation. Check if the patient has any prior allergies or any form of medication. Formulate medical diagnosis based on clinical reasoning from the history obtained and visual observations of patient during the consultation. These are what you will need to justify if you are faced with a complaint to the medical counsel. The medical counsel will expect you to have covered all these points, and your notes must properly document these points. So what are the considerations that we often face in complaints against medical practitioners for issue of medical certificate? Complaints are that the patient wants the medical certificate, that the person paying for medical certificate or the consultation try to influence the issue of the medical certificates to make sure there is benefit to the person paying rather than the patient. For complaints that durations are too short, we always get the common complaint that the doctors are influenced by the employers not to issue too many medical certificates or too long a medical certificate. We actually had a case where the employer, where the doctor was faced with a complaint to the medical counsel. Now, the doctor was quite innocent. What happened was that the patient had served his notice of termination of employment, taken leave, but needed medical certificate to cover the extra portion of the leave to the end of her employment date. She did not tell the doctor this. She went to see the doctor and told the doctor, "I'm not well. Can I have 3 days MC?" The doctor, after examination, gave the patient 3 days MC. And a few months later, there was a complaint from the received from the medical counsel that the employer has complained that this patient had taken medical leave just not to appear at the worksite to end her notice period. So the doctor was caught out, and at the end of the day, we were able to convince the medical counsel that the patient did have some ailments, but it was a touch and go case because was there sufficient ailments? Was there a sufficient ailment to justify a medical certificate for 3 days? I will not touch on medical certificates issued by specialists for industrial accidents, but as Lawrence said, you are expected to know the circumstances in which you offer a medical certificate. And what's interesting for industrial accident cases, the most recent development is when there's an allegation that the medical certificates were not handed over to the patient as required by the ethical guidelines, but were handed over to a supervisor in the presence of the worker. The doctor didn't know about it because he's inside the room. And the other interesting development is that we have recent cases of patients rejecting medical certificates. But to be fair, these are mainly industrial accident cases. I will next dwell on next slide, please. This is where I jump my talk that medical certificate must be given directly to the patient. It is your responsibility to the patient. It is the patient's responsibility to hand the medical certificates to his employer. You must not disclose the diagnosis of a medical certificate without consent. We often get employers calling up and asking what's the diagnosis. There is an exception to this for medical certificates for the state court. If you want to prescribe light duties, you need to make sure that you know what are the light duties available. You must prescribe the limitations as detailed as possible to help the employers understand what you intend to help the patient with. Remember, it is always what is the best interest of the patient and not what is in the best interest of the employer. If light duties, as Lawrence said, if light duties are not available or you're not certain, give the patient a full medical leave. Next. Okay, the state court medical leaves are a special category of themselves. Now, I have brought this up because I think it is based on an actual case, and I think it is good to bring it to the attention of general practitioners and other people, any other person who are asked to issue medical certificate to exempt a person for attendance in court. The recent case we have was that the medical practitioner did not comply with this practice direction and was handed a letter of advice by the medical counsel. So what's so special about this state court practice direction, which is reflected in the SMA guidelines? Okay. First, you must make sure your name and registration number is on the certificate, your clinic name is there, your contact details is there, your signature is there, and if no signature is required, then you must or state that no signature is required if the medical certificate is electronically generated. You must state to the effect that the patient is medically unfit to attend court and specify the dates. You must also specify the diagnosis, plus a brief description of symptoms and condition, forming the basis for stating that the patient is medically unfit to attend court, unless the diagnosis cannot or should not be disclosed. Now, you may say, would this breach the patient's your duty or confidentiality to the patient? My answer to that is that your medical certificate is given to the patient. It is for the patient to hand the certificate to the court. And you must date the medical certificate and clearly disclose the difference between the date where this date differs from the date of the consultation. So if he consults you on Monday and you are backdating or forward dating the medical certificate exemption from court, you must explain why. Next slide, please. If you feel strongly that you need to add additional details, you can include this in the memorandum to the certificate. Now, your memorandum should be addressed to the judge, magistrate, or subordinate courts, or the judge, magistrate of the Supreme Court, not to whom it may concern. This will be consistent with the relatively new Section 39A of the Health Services Act for issuance of medical certificate, which was effective on 14 October 2024. Now, what happens if your medical certificate fails to comply with the state court direction? Firstly, it may be rejected by the court. Next slide, please. There's a complaint to the SMC. There was an actual case where there was a lack of knowledge of proper medical documentation court proceedings. A memo was issued instead of providing a medical certificate. This is inappropriate. The party of the court proceeding lodged a complaint to the SMC, making various allegations. The IC investigating committee considered that the doctor acknowledged the mistake for issuing a memo, plus first time writing letter for such cases, issued the doctor a letter of advice. Teleconsultation case. What happened? The complaint was camera was not turned on due to technical issues. The doctor was not aware. Next case, please. Next slide, please. Consultation was conducted through a checkbox. Consultation completed within a minute. The MC was issued. The complaints committee looked at the case notes and came to the conclusion that the consultation was very brief. The doctor could not have conducted comprehensive history taking and adequate assessment. And this is where I has earlier stated the doctor should have taken more time to assess the patient visually, obtain a detailed history of the ailments, complainer during consultation, pose relevant questions to check the symptoms patient may be experiencing prior to the teleconsultation, check if the patient had any prior allergies to any form of medication, check if the patient had any allergies that may display similar symptoms when aggravated, formulate a medical diagnosis based on clinical reasoning from the history obtained and visual observations of patient prior teleconsultation. Now, and most importantly, all this should have been documented in the case notes. I know teleconsultation is very, very attractive. I myself use teleconsultation because it avoids going to the doctor. I don't have to go see a doctor. Medicine are delivered to my house. But for the medical practitioner, these are the minimum the SMC expects you when carrying a teleconsultation. I have no further input unless there are any questions.
Thank you, Mr. Charles, for sharing with us on the legal aspects, and I hope that has also given us a better understanding about the legality surrounding MC. So this brings us to the next segment, which is a 5-minute break. And right now the time is 2:55, so we're on time. So we could take a quick break, and we can come back at 3 p.m. Thank you very much.
Patient.
Thank you, everyone. Welcome back. The time is 3 o'clock. So we'd like to move on to the next segment. So for the next segment, we'll have the case-based discussion, which will help us apply theory to practice. And we are very privileged to have with us, besides Prof. Lawrence Ng and Mr. Charles Lin, is Dr. Sarah Jamieson from medical legal consultant from the Medical Protection Singapore. So Dr. Sarah graduated from the University College London in 2008 with a degree in medicine, having also obtained the BSc in neuroscience and basic medical sciences. She trained in psychiatry in West London, gaining membership with the Royal College of Psychiatrists. She has also worked as a postgraduate medical education and clinical risk fellow and completed a postgraduate diploma in clinical education at UCL Institute of Education. Joining Medical Protection in 2016, Dr. Sarah initially supported members in the UK before moving to assist members in Asia and the Caribbean and the Bermuda. She has since obtained a postgraduate diploma in governance, risk, and compliance from the International Compliance Association, is a member of the ICA. She has also a diploma in legal medicine from the Faculty of Forensic and Legal Medicine and completed an LLM in medical law at Queen Mary, University of London. So without further delay, let me hand over to Sarah, who will take us through the case discussion. Sarah, over to you.
Thank you. Bear with me. I think I am now sharing my slides.
Yes, we can see your screen.
Fantastic. Thank you. Right. Just well, thank you so much for having me today. It's a pleasure to be here. I think this is a fascinating topic and one where you have the clinical, I mean, just even looking at the questions coming through, the clinical aspect, but also very, very strongly thinking about the medical, legal, and the ethical aspects as well. I was tasked to provide some cases, and obviously that's what we deal with at MPS. And I did do a search on our cases, an informal search, and I found that the strongest themes I saw coming through were consistent, obviously, with what Charles had said. So I essentially have two cases along those themes, which I hope will be sort of good points for discussion. This is just a special college promo. I thought I would put it up there for you. You can take scan the QR code and for GPs. Now let's just start with the cases. So this case, I have to say these cases have to be anonymized, so they've been changed to a certain degree. But like I say, I tried to draw on the themes and the learning points. Dr. G is a family physician, and he saw a patient, a 37-year-old patient, who had a fall and complained of ankle pain and some difficulty walking. Dr. G examined the patient, found the ankle to be swollen, suggested an X-ray, and the X-ray came back as normal. So the GP prescribed some non-steroidals and advised to return after a week. The patient asked for a medical certificate as she had difficulty walking, and an MC was issued for 2 days. Unfortunately, she returned to her job when she returned to her job as a nurse in a hospital, she had another fall and had to go to hospital. The patient then complained to the SMC, alleging that Dr. G should have provided her with more sick leave, as her job requires her to be on her feet all day. And she also alleged that she needed to have extensive physiotherapy, which would not have been necessary if a medical certificate was provided for the appropriate duration. And this is the point when the doctor approaches MPS, when they have a letter from the SMC. And it's really at that point when we think about, okay, I don't think this GP or family physician meant any harm. Obviously, we all go into clinical medicine to good. I think the oversight here was not exploring what the patient's work was. What has to happen is we provide with the medical counsel, we provide an explanation, provide some submissions. We work with a lawyer and trying to justify or at least explain the situation. And sometimes, sometimes there was an oversight here, should have explored the patient's work to understand whether 2 days is indeed appropriate. If she's going to go back after 2 days, is that enough, or what are the other considerations with regards to her work? So and it didn't happen in this case, but it's also entirely possible for this patient, for example, to have demanded from Dr. G that he covers the cost of the treatment that was required. So there can be monetary consequences, which we do sometimes see, of course. So what's important when issuing an MC? Well, I would say these 3 things mainly from a kind of medico-legal perspective. So exploration of the work itself, what is involved. If you think about light duties, what do the light duties involve, as well as a consideration for the relationship between the clinical presentation and the work to be carried out. And this was discussed already, sort of the justification for the MC. For example, in this case, maybe the need to prevent weight bearing during recovery period of an injury, for example, or following a procedure. And then, of course, making sure this is documented, because when we provide our submissions, it's one thing to say, well, this is what I thought, if you do remember. It's another thing to have it in the records, because there's nothing more strong, robust, and valuable than having a contemporaneous record. And with this case that I described, this is the kind of case where you'd get from the SMC kind of a letter of advice, hopefully, just saying, make sure you do a proper assessment of the situation before issuing an MC. And I wanted to, I suppose, at this point, before going to the next case, just open this up to the floor, for the rest of the panel, and invite any comments for the next few minutes. If anyone else, any of colleagues, I don't know, Charles or anyone else, Professor, if any comments from you about a case like this. I did see that like I say, I did a search, and the 2 themes were failure to issue a medical certificate and insufficient duration. So I thought I would go with one which was an insufficient duration. Maybe, yeah. Anyone else? Any comments from this, Charles, perhaps, or?
I think Sarah, you are correct in so far as it is important to know more history of the patient's work background to ascertain what's the job and what does it entail, and then ask the patient whether 2 days MC will suffice in terms of her job scope. I do empathize with medical practitioners, because there's always the other side of the coin where the patient is trying to hunt for MC, not to go to work. So end of the day, if the matter goes to medical counsel, if your documentation is sufficiently able to demonstrate that you took a proper history, came to a proper clinical diagnosis, and actually examined the patient's background, you should not be getting more than a letter of advice. I agree.
Thank you so much. And I think one of the thoughts that come to mind, and I think I can see in some of the questions coming through, is shouldn't the patient just have come back? And I think that's really interesting, because obviously the patient has some kind of responsibility, right? The patient should know, they know what their work is. And unfortunately, in the situation, this has come from a real, like I say, I've changed the facts, but it has come from a real case. It's still about the clinical advice. It's the doctor has that position, and they are, it's a bit like treatment, isn't it? You're providing 2 days rest, and unfortunately, even though yes, the patient could have, but maybe she thought it would be okay. The doctor thinks only 2 days of rest is needed, and I can return to work. So I think safety netting is important as well in these situations. But you're right, the patient is an autonomous, in this case, adult, but unfortunately it is medical advice, and the MC is considered as part of the medical management in this situation. I don't know if there are any other comments before I move on to the next case. Okay. I'll leave some time at the end of this session. So we have case number 2. We have Dr. B, a family physician who saw a 23-year-old construction worker who had an injury, and there was a company representative in attendance at this appointment. On examination, there was an open wound on the palmar aspect, so we decided to make a referral to a hand surgeon immediately, obviously seeing the seriousness of it. And the patient then had surgical debridement. A week later, the patient attended Dr. B again and was found that there was some pain, residual pain, but the wound was healing well. And he knew that the patient was due to be seeing the surgeon again in a few days. Now, Dr. B didn't hear anything from the patient again until learning that there was a complaint made to the Ministry of Manpower and alleging that an MC was not and should have been issued following the wound review, the follow-up appointment by the family physician. And we do see a number of cases which sort of arose from referrals from the ministry. And the concern very often is this. The concern is that the sort of potential allegation is that perhaps the doctor is taking into consideration extraneous factors. And what needs to be focused on is just the clinical assessment. Now, in this case, Dr. B did not issue an MC at the wound review appointment. He had assumed that there was an MC of sufficient duration by the surgeon following the procedure, so did not explore this. And this was perhaps more of an oversight, but sometimes such clinical oversights can result in a possible perception or allegation of a very different nature, and ones that suggest possible collusion or conflicts of interest, at the very least, in inappropriate conduct. And I included this case for 2 reasons. Firstly, because of the 3 points of clinical contact, we have the initial assessment, we have the surgical review and procedure, and then we have the review with the family physician again, and of course the future review with the surgeon. Now, when we see patients, sometimes we are just 1 point on a timeline with activity and clinical interaction beforehand and afterwards. So I just wanted the rest of the panel to have a think about where would be the appropriate points for issuing an MC and who should do it. And I think the key here is sort of asking and exploring, what is the situation? When are you due to go back to work? That kind of thing. And also just to note the attendance of the representative at the first appointment, and again, for the rest of the panel, considerations about this, how to manage the presence of this third party, being mindful of this possible allegation of extraneous factors. And I think, Charles, you touched on this as well. So we've got B41, where it discusses really focus on the clinical assessment. You need to not be concerned about all the other sort of potential issues, but also here in the handbook of medical ethics, where you've got the corresponding guidance, sort of almost an additional advice. It mentions that sometimes doctors limit their medical certificates for workers according to requirements of the ministry to report injuries, so that they do not have to report, and it's wrong to consider employers' preferences. And the issue is, I think many doctors are not necessarily doing this, but when they issue a certificate that is short, that you can end up with this perception or a possible allegation that you then have to go and justify. So I think including in the records, for example, justification along with your assessment is important. But I just wanted to open up to the panel, see if there are any thoughts about these cases.
Sarah, can you put the Dr. Thiru here? Can you put the case on? Yeah,
One.
so here I think it's very clear. No, case 2. Let me get to case 2.
Thank you.
I think in case 2, let's be clear. In this referral, the doctor or the GP has actually transferred the care of the patient to the surgeon. All right. Now, then the question is, when the patient comes back, what is his duty must be clear. So he has to collaborate with the surgeon and find out exactly what or how the patient should be managed. Because If there's no communication between the surgeon and the GP, then that's where the problem lies. All right. So, and I think that the question is whether the GP had a summary of the case report or not. And if yet the summary of the case report, there would be evidence of the duration of MC, and he will know clearly what is his role. Maybe it's just to see whether there's any post-surgical infection. And then, of course, exploring the patient's occupational status and the effect of a hand injury on a construction worker must take place. So both the doctors, I think both the surgeon and the GP are not in good communication and are not clear in their roles as far as this patient is concerned. And I think that's where the issue lies. So my advice for family physicians is that if you refer a case like this, it's a surgical case, all right, then you say, I'm transferring this to your care. If you need any further help, please send me a report or otherwise, or if the report is not available, then I think the GP should call up the surgeon. And that would help to resolve a lot of the issues that have come up. Over to you.
Yes, thank you. I think that's exactly it. I think it's having the I won't say curiosity, but it's about good team management. At the center, you've got the patient, right? And there's all these other clinicians, and I think that's why I wanted to use this, because of the continuity and the timeline. And like you say, who is responsible for what is your role? And what was the purpose of the appointment? Was the transfer of care, what was the care transferred? And I think you can easily fall into a situation where you think, oh, well, they're being seen again and they're still under the care. This is just a sort of a check-in or something, or what's the cause? So I think, I absolutely. I don't know if you've got anything else to add, Charles.
But I think it's certainly correct. Communications between the referring GP and the surgeon is very important. But we do know of cases where after surgery by the surgeon, the patient is sent back to the GP for the step-down care of wound cleaning, bandage changing. And this is where we are very correct. Firstly, the GP should have asked the patient whether he's on MC. And if the patient is not able to answer, he should pick up the phone and call the surgeon and ask what's happening and whether the patient has been given MC. Now, if I look at the matter, I don't speak for the SMC, but based on SMC cases, this is the minimum the SMC would expect a GP to do, because was it in the best interest of the patient for him to be without a medical certificate? SMC is very concerned about this. That the health of the worker should never be compromised. So yeah, it's so simple as picking up the phone and calling the surgeon if you're not sure. And then just to come back to the issue of the company representative in attendance, if it may help, first attendance, maybe you can say have him in the consult room, but you need to think about patient confidentiality. And if the representative in the room, would it influence the patient to say certain things or not say certain things? So normally, I think it's best to have the patient representative outside the consult room, see the patient alone, unless you have difficulties in the translation and interpreter, then you ask the company representative or someone to come in to interpret for you. Otherwise, don't see the patient in the presence of the company representative. You need to speak to him alone.
Okay, thank you. No, and absolutely, I agree with that. I don't know if any other comments on that case. I think that's helpful. That's kind of what I wanted to draw attention to in there with regards to the representative. And I think that's where you can get the issue of possible sort of extraneous factors, even if the clinician is not, is not actually in collusion or whatever. So I think I also just wanted to draw attention just ever so briefly in this description. I know we're running out of time. This other thing about, because we were talking about sort of safety netting as well, and sort of coming back for more MCs, there is a mention here Even if you arrange for reviews at short intervals, you should consider that having patients come back frequently when not clinically necessary would not be in the best interest of the patient. So I think as well, there's quite a lot. It's very interesting that the issue of sort of the duration and the length of leave. And actually, if you think they need this time off of a certain time off of a certain length to issue it, and obviously sometimes I think clinicians will also feel it might be safer to have sort of short and then short leave and then review for follow up and review and issue sort of several MCs like that. So I just want to draw attention because this all comes under the concern about extraneous factors.
And the SMC is very concerned about extraneous factors. Remember that if the matter goes to the SMC, you'll be judged by your peers who are very experienced medical practitioners. We actually have a case, ongoing case now, where the doctor gave 2 days MC and 7 days light duty. And the DT said, in that case, why are you giving him very strong medication for pain relief for 14 days? Contradicts your light duty. If he doesn't have pain, why do you give him 14 days of very strong pain relief killer? So I think the doctor had a lot. I mean, the only answer the doctor can say is that he was concerned the patient may default and so he has some medication. But I don't think that's acceptable reasoning. Remember, the SMC are your peers. They will judge you as peers and they will ask you and look at everything you did for the patient. End of the day, was it in the best interest of the patient?
Okay, may I say something about the third party in the room? Right? This is what normally is a dyadic consultation between the patient and the doctor. There are many situations there's a third party there. Now, the third party is somebody you first need to identify who is and the relationship. Now, third party can be helpful, can be neutral, or can be an impediment. And that is the judgment that you have to make, all right, in terms of how you want to engage the third party for the benefit of the patient. And I think, as Charles mentioned, whenever you have a triadic consultation, you should then create time for private time for the patient. And sometimes if the person has a bona fide relationship like a parent, you can actually create time for the third party so that you get a different perspective. So having the representative per se is not harmful. I think it is important for the doctor to make a judgment whether the representative is, as I said, helping or is just neutral there to support psychologically, or is actually impeding the doctor in his assessment and his work. Over to you.
Before we leave this issue, I think Prof. Thiru mentioned that under the Section 33 of the Health Services Act, a doctor is now responsible for everything that happens in the clinic. So, issuance of medical leave for a patient, you cannot say that the nurse didn't give it to the patient because under the SMC Ethical Code, the medical certificate must always be given to the patient. But we have many cases where the nurse, when in front of the patient, the company representative say, give it to me. And the doctor is not aware of this totally. And then there's a complaint that I never got my medical certificate. And it transpired that it was the employer's representative took it from them in front of the employee. Now, how that goes is between the employer and the employee. But for the doctor, he did not comply with SMC Ethical Code to give insist that it be given to the employee. And he was caught up innocently insofar he didn't know it happened. So there must be a clinic protocol. I suggest that you must ensure that the medical leave is given to the employee, and if there is any deviation, the nurse must be told to tell you. So you know and can have a query to the employee why he's willing to give the medical leave to the employer.
Thank you so much. And I think it's right. We classically in medicine, you've got the doctor and the patient, and like Professor said, you might have someone else that can provide a collateral history. And this is a very unique situation, really, where there are clear differing interests at play. So I think a lot of caution has to be exercised. I think that's all I have time for the cases, but I believe we're moving on to cases now. So thank you for your time. But I wonder if this has also sort of raised any points that we could explore further in the Q&A. Thank you.
Thank you so much, thank you so much, Sarah, and also for Charles and Prof. Thiru for stepping in to also share your insights. And I hope the two cases has been useful for all of us who are attending a seminar to think through some of the issues and how do we navigate some of the background difficulties and that we face day to day. So this brings us to the last segment, which I believe is one of the segments that all of us been looking for, which is the Q&A and the panel discussion. So we're very privileged today to have with us our panelists, Prof. Lawrence Ng, who is a first speaker, and of course, Mr. Charles Lin, Dr. Sarah, and of course, Dr. Thiru. Right. So Dr. Thiru, just a bit about Prof. Thiru or Dr. Thiru, as we know him. He's no stranger to all of us. All of us know him. He's been our teacher in ethics and professionalism for many years. He currently holds the position of adjunct professor at the Office of Academic Affairs at the Duke NUS Medical School, Singapore. He's one of the founding faculty of the Duke NUS Medical School, having joined the school in 2007. He's also the founding director of the Singapore Medical Association Centre for Medical Ethics and Professionalism, serving as the executive director from 2000 to 2003 and 2011 to 2016. And he currently holds the position of the academic director since 2018. Prof. Thiru graduated from the University of Malaya, KL, in 1972, and went on to train to be internal med and dermatology. He was the founding director of SGH Dermatology Department in 2002 and served in SGH Dermatology to 2017. He was the Group Chief Medical Officer of IHH Healthcare from May 2017 and retired in 2019. And he holds a master's degrees in healthcare ethics and law from the University of Manchester and completed the master's in counseling Monash in 2015. So very distinguished panelists we have here. So maybe there have been thank you everyone for posting your questions on the Q&A chat. And I think we have picked up a few themes regarding MCs. And maybe I'll just start off first by just to respond to the question by Dr. Loh. So he mentioned about court attendance. So his question was that his CMS provider informed him that actually, GPs are not allowed to issue MCs for absence from court, and whether there's any truth in that. I believe this has been shared in our earlier slides, but maybe I could get Dr. Lawrence to start off with this and to provide the insights on this. So can GPs issue MC for absence from court?
Yes, GPs can issue MCs for absence from court, but as what Charles has pointed out, there are all the conditions that must be met. So I won't repeat them again. And make sure that the condition warrants the unfit to attend court certificate. I don't know if Charles got anything to add.
Charles,
nothing. I confirm that there is no distinction as to whether GPs or only whether GPs or only whether specialists can issue medical certificate for attendance to excuse attendance in court. The Medical Registration Act does not put any distinction or restrictions. So long as you're a medical practitioner holding a practicing cert, you can issue a medical certificate. But you must, for court attendance, for court purposes, you must comply with the practice directions of the court.
Thank you. Thank you, Charles. Yeah, so I think just for everyone's knowledge, you can actually look it up at the State's Courts Practice Direction 2021, Section 14, absence from court on medical grounds. I'll put a link up there and you can refer to it to see exactly the requirements that our speakers have also put up. And I believe the slides could be available as well. Victoria, do you want to take the next question?
You can also look at SMA Circular. Sorry, it's SMA Circular, second issue, 30th November 2001. It replicates the court's practice direction.
SMC.
SMA.
Okay.
Where they extracted the state court's requirements.
Next question. I think another one that a lot of people ask is on hospitalization leave. So can GPs issue hospitalization leave? And can they also extend hospitalization leave? So maybe I will get Dr. Lawrence to start off, and then maybe Charles, and maybe Dr. Thiru. Thank you.
I think the recent circulars that came out says that GPs cannot issue hospitalization leave. So by the same extension, by the same reasoning, I think it's best to send the patient back to the hospital or the referring or the particular hospital specialist involved. That would be the short answer to the question.
So they can't extend it either, right?
That is what I
You
came to understand.
Yeah. That's also
Yeah,
my
Charles, please.
understanding. That's also my understanding that for hospitalization leave, the patient should be referred back to the specialist who gave the initial leave. Bearing in mind that the Employment Act provides for 2 months of hospitalization leave, so there are legal ramifications regarding hospitalization leave. And I think there was one requirement that for hospitalization leave, the patient must be in hospital. It's not so simple unless there's a special reason for the patient, for the specialist to certify that this is hospitalization leave, but he can do it at home. So it is really within a specialist purview, and GPs should refer back to the specialist.
I think, Victoria, it's not fair for the GP to take on the job because he has not seen the patient earlier, neither has he information that is necessary in terms of the patient's diagnosis and investigations to actually then make a decision. So I would totally agree with both of them. Don't take up this job. It's always best that you ask the patient to go back to see the specialist. If you really want to be friendly and helpful, you can call the specialist up and have a conversation with him and then share that information. And if that shared decision says, yes, you go ahead and extend, then you probably can defend yourself rather than making a decision on your own. Over to you.
Sarah, do you have anything else to add?
Yeah. So just to add, I think some that participants has also added complexity to that HL issue. So we do know that doctors, GPs can't issue HL, but on the ground, some of the patients, they are foreigners, they get their treatment done overseas and they come and they work in Singapore and they return to Singapore and I see in my own experience, some patients actually come back, especially from, for example, JP, just to see a local doctor to get the MC endorsed. If not, their employer is not going to endorse. And some of these MCs could be hospitalization leave for surgeries that are done for genuine conditions done overseas. So on that note, maybe I can start off with Lawrence. Well, how do you think on the ground GPs can handle such situations? And I guess
This is always difficult to answer because you are certifying for sick leave as per your assessment. So unless it's something very surgical, let's say he had a road traffic accident in Thailand that was a week ago, then he had an operation to fix the fractures and all that, then you have a start date. But if he had some vague illness, some giddiness or what, then it's difficult. So I've read in the articles, in the absence of some measurable pathology, then it's difficult to say when did the illness start. So that is the crux of the matter. Can you actually objectively say when did the illness start? Now, as for the MC that's issued by another doctor in another country, employers are actually not obliged to accept those MCs. And definitely, even if they accept that the patient was absent from work, they are not obliged to pay for that period that was written by another country's doctors. So there's also an issue of what is accepted by the employer. And by employer, I mean the HR. And then the HR practitioners will have their own HR policies. So I would say that if you err on the side of caution, you will look for measurable pathology or something very tangible that you can work with. Over to you.
Thank you, Dr. Lawrence. I think on that note, we do see that as you have shared in your earlier slides that that under the Employment Act, the employers are supposed to recognize and give paid sick leave for MCs that are legitimate. And from the legitimate point of view or recognized point of view, it is under the MRA, whereby MC that's only issued by a registered medical practitioner in Singapore. So I guess this question also has a complexity of two issues. One is that about MC endorsement. And also, I guess the other thing is about whether GPs can actually extend hospitalization leave. And from what I hear from, if I can summarize what you mentioned, is that the doctor should not endorse the MC, but need to make a independent assessment and to issue the MC accordingly. And of course, GPs can't issue a hospitalization leave. So if the GP can't issue a hospitalization leave in such case, I say it's like an appendectomy done overseas, and he needs it was given a hospitalization leave. Then how can GPs in Singapore navigate this situation?
I think, James, you have conflated three issues. One is extending an MC for a current illness. All right. Now, that part of it is a little bit easier because you examine the patient and make a medical assessment on that day. And then you should have access to information about his previous illness. Ideally, if he has got some medical records or summary of records, right, that will give you more evidence to know what was happening before. So your decision to extend an MC should be what is the situation of the patient on that day you saw him and the impact of that on his employment. Okay, I think that's the important thing. That's what the first part. Endorsement of MCs is a category of work that has been created by employers and HR. There is actually no defined endorsement of MC, both in law and ethics in the Singapore context. And the SMC actually discourages endorsement of MC. So the answer to the problem is that the problem is lying in the minds of the HR or the employer. So you should communicate with the employer and say, look, I cannot endorse an MC, but do you want me to be a medical examiner to give you a medical expert report of what happened to the patient in the last 2 weeks or so? Now, to do that, you need the medical records or a case summary of what happened in the country where the patient came from. Now, without that, you cannot then give an opinion. So in the second situation of endorsement, if you really want to do this job, all right, I mean, I think most GPs don't want to do this job, then you become a medical examiner, examining the records, examining the patient, and then give an expert opinion. So my advice would be the simple solution is speak to the HR and find out what do you want me to do, right? And therefore, if they want you to be a medical examiner, then there's a different story. And just tell them, look, this is between you and your employee, and you will have to look after the welfare of the employee and take it from there. And the decision whether they are going to pay for his sickness that they want to do. So I would put it that way, rather than the doctors taking this responsibility and trying to create a solution based on the current medical certification approach. I think we must be very clear the medical certificate approach is really about a patient who comes to see you, he's sick. And part of the sickness is that he may affect his work. It may affect other employees or colleagues. It may be a safety issue. Now, there is when the doctor decides, based on the assessment, to issue medical certificate so that he can get better quickly, all right, or does not have complications because he doesn't have medical leave, or he may become infectious in his workplace, or as somebody says, what are the medication? If he's a bus driver, a school bus driver, and you are giving him antihistamines, then you have to make a judgment whether the person should be driving the bus or not. So I think it's important for us to be quite clear All right, what is the core concept of this medical certificate as enshrined by the Employment Act and the MRA, and then all the other peripheral issues that come up. We can talk about timing and other things, but I think it's, you need to be quite clear on that point. I hope I have made it clear.
Thanks, Prof. Thank you for helping us to clarify the complexities in such a
Can I
situation.
just jump in? Can I just jump in? I think whatever happened antecedent before the patient came to see you, actually you are not in any control. And like Prof. Thiru said, until you have evidence from the documentation, a memorandum from the treating doctor, you don't know what's going on. So the other thing I'd like to add is that actually when it comes to writing MC, you're actually not autonomy or patient-centered really. You are, I would say, evidence-centered, and you are actually paternalistic. You are absolutely paternalistic. You are playing the role of the assessor. You are playing the role of a medical examiner. You are working on evidence that are presented before you, and you have to have justification for what you are going to do, and you have to document. You're functioning essentially like a judge. So it is very different from a therapeutic relationship where you are, trying to do a history, a physical examination, and trying to be very a lot of empathy involved. You have to take that off, the hat off, and then put on a different hat. So this is the difference. And a lot of doctors can only function with one hat. They either become very harsh with the patient, and then, of course, then you got no business, and you may as well close up the clinic. Or you can be very relaxed about giving the MCs, and then you get into trouble from all sorts of complaints. So from all my reading, I think this is where the dilemma, the conflict comes in, the difficulty that a lot of doctors play, the two roles, And that's why some of us hate to go to work, because, oh no, another day where 1/4 of my patients are going to get MCs, and do I give in or do I not give in? If I don't give in, I waste a lot of time, and then my clinic starts to pile up, or I give in and then I feel very lousy about myself. So, but I think we have to be clear about which hat you're wearing, and if you're going to wear the hat of a judge, a medical examiner, you have to work on evidence, and you have to be justifiable, and you have to document down what you do and why you do what you do. Over.
James, I think I need to clarify a few things. This is not an issue of conflict of interest. It's an issue of competing interests. All right, we must be very clear. All right. The doctor, as you said, has two roles. One as a healer, and that role as a healer actually extends to MC because the MC is part of the healing process. Now, then the second part is that MC then creates another issue between the employee and the employer. Because if the patient has an MC, he will get paid leave, and the employer has to give him paid leave, pay for his, for his days he's absent. So I think it's important for us to first focus on our duty as a healer, and then decide whether the MC is going to be part of the healing process. And then you have to then certify that accordingly. Now, HRs have a lot of policy issues which may interfere. But when you start certifying, okay, this person needs MC, then you put on the hat as an examiner. And that is where you then have to be very objective, as described in an accurate and comprehensive, to support the fact that this was not done in a frivolous manner. It was evidence-based, due diligence, and appropriately documented, because that is a duty and a privilege given by society to us through the Employment Act. Over to you.
Thank you so much for giving a very in-depth deep dive into the issues surrounding this. Council, I just want to ask you, do you think there are any legal safeguards when it comes to such situations? Are there that you're aware of?
You mean regarding endorsing of MCs or?
Yeah, regarding endorsings of MCs.
From a legal perspective, under the MRA, only an MC issued by medical practitioner is recognized. Now, you endorse another medical practitioner MC. Can you say that's your MC? I don't think so legally. And being on this topic, I think a similar issue we find is where patients return from overseas and ask the GP, ask the doctor, can you continue this medication which the overseas doctor prescribed me? I think the same considerations apply, right? At all times, I think you need to carry out your own clinical examination. If the patient insists or the HR insists, if I were you, I would decline to endorse any MC or to carry on prescription given by overseas doctor, because you need to be able to justify your prescription. You need to be able to justify why you endorse the MC, why you think the patient is entitled to MC. I mean, if you're going to endorse the MC, you must well issue him a new MC after the clinical examination, because under the Act, only your MC is recognized. I don't think the MOM, if the matter goes to court and the patient and the MC is challenged, I don't think your MC will be recognized, your endorsement of the MC will be recognized. I mean, your endorsement of foreign MC will be recognized because it is not MC recognized by you or valid under the MRA or under the SMC.
Thank you, Charles. I
Simple
think that
question, what's so
helps.
difficult about? I think you should be stand firm with the HR, like Prof. Tiro say, they have their own agenda, but you as a professional, your only agenda, you only two agendas: best interest of patients and comply with SMC ethical code and guidelines.
Thank you so much, Charles. I think I'll hand over Vic for the next question.
Yeah, next question. Actually, I see Sarah is not here. So I think I will choose the one that has the most number of discussion, I think, in the chat. So I thought I would just openly ask the question. So it's actually about dating of MCs. I think that has come up a lot in the chat and in the Q&A. So I think a lot is see you at the end of the day. Then can you date your MC the day after? And I think there's a lot also asking, what if the patient said that they were ill yesterday, but only managed to come and see you today? So how should they go about doing that? Yeah, I see Sarah. Maybe Sarah, you wanna kick the ball,
Yes.
get the ball rolling. Thank you.
Apologies. I
Sarah
was
bravely volunteered.
I was here just by showing up. No, I think it might be helpful. I mean, what we have is we've got the code and the guidelines, which is the regulatory framework, and then we've got all these complications and nuances which are coming through in the questions about specifics. So it might be helpful for just looking back at the ECEG. They do mention the issue of backdating, and I think it's almost akin to we have to remember that a certificate is something that you sign. It's like a record, right? So it's of the day that you see them and you make the assessment and you do the certification. So the ECEG does say you must not post-date or backdate the date of issue of your medical certificate. It must be the day of the consultation or treatment. The date you begin coverage may be before the date of issue, only if it is clear to you that the patient's absence from work prior to the date of issue is consistent with the clinical presentation. So hopefully that provides that's sort of a little bit helpful. And I think the handbook, the ethical handbook, might also go into it a little bit more. But I think if you think about it, it makes sense, doesn't it? Because it's like records. It's the date that you are doing it, but if they were unwell yesterday, then it makes sense that this is part of the same illness, and it's not, it doesn't contradict, what they're saying yesterday and what you see today. If it all makes sense clinically to you as well, then that could be considered as the same sort of period of leave. And actually, the handbook does go into it a little bit more. It repeats it, and then it says, and then it talks about sort of possible anticipatory, but we won't go into that. Perhaps, yeah, are we looking at the past first instead of looking at the future? I don't know if anyone else has got anything else to say.
Sarah, you're correct insofar as the ECEG explanation actually says that the MC should not begin after the day of consult. The reason is because your MC should not be anticipatory. Right. And it's at page 49. I was just checking because MC's coverage should not be anticipatory in nature. So I think you should at least start from the date of issue or the date of consult, actually. That's
They
all.
do mention, Charles, as well. There's a little bit of a there may be sensible reasons for you to post-date the start of coverage, such as when patients see you after
Yes.
work on the day of issue, thus not requiring coverage on that day, or seeing you at the start of a weekend. So obviously you don't need to do it on that day. So, and again, it's really all about justification, right? So,
Yes.
you know, even if you say, although it's obvious, of course, in terms of the timing of an appointment, you still say, patients completed his day of work or whatever, seen in the evening, therefore commencing, you know, medical certificate of sick leave sort of from tomorrow or something like that. So I think they've tried to include a little bit of that kind of those nuances in the guide.
I think there are at least two or three issues here, right? One issue is the patient has come to see you on day one, right? Order 0. Now, a good example is come to see you and you have diagnosed a patient to have chicken pox. All right. And the patient says, I had this rash for 3 days. It was itchy. All right. And I couldn't come to see you. I used calamine lotion, whatever. Now, on that time, when you examine and you know that this is continuation of a known disease, and that is very plausible, all right, as a reasonable doctor to make a conclusion that the patient's illness started 3 days ago. Now, if you have that kind of evidence, then I think it makes sense, all right? Not in terms of the date of issue of the MC, but to start the MC a bit earlier, all right? And then, but the date of issuing the MC must be the date when you examine the patient, because that's a certification requirement. Now, then the question about timing, right? And if you're not satisfied, if the patient say, my headache started 2 days ago and everything is fine now, and then obviously the facts of the case do not support you trying to, bring the supply or offer the MC 2 or 3 days earlier. I think the question about the end of the day work, I think, again, you can use the reasonable doctors, but you need to ask the question of the patient's work, what time is the shift, what time it ended. And it's perfectly all right, say, if he sees you at 8 p.m., to put the date on day you issue the MC, but you can start the MC the following day, make some notes, all right, in your documentation. I think that's a question of what would a reasonable doctor do in that kind of a situation, remembering that the MC is going to help the patient get better. Or, right, now that's where the part comes in, whether you should actually go into getting him some help to get paid leave for the time he didn't see you, right? I think that's where you have to be a bit careful and make a judgment according to the what shall we say, the facts of the case, in the sense that the part about the MC is sticky because the patient is entitled to paid leave. It's a question of dollars and cents, right? And therefore, you have to be very clear, what are you making a decision on? Are you helping the patient get better? Are you helping the patient get some money because he didn't turn up for work? And I think that's really where the difficulty lies.
Actually,
Go ahead.
can I say? Yeah, I realized that when in the issue of consent taking and the consent process, the test is that of a reasonable patient. What he wants to know. In the issue of MC, like Prof. Thiru said, the test is that of a reasonable doctor. What would a reasonable doctor do in this and that of a case? That has been my realization from thinking about this topic.
Thank you so much for sharing all that. I think on that related question on the dating of MC, the next question and probably the last question in view of time is on the duration of the MC. So two parts to that. The first part is there, I think some of the participants have asked, is there a maximum duration of MC that a GP can give? And the second part is that if a doctor assesses that the patient needs this amount of days of MC, but the patient decline and wish for a shorter period, how should the doctor respond or manage this situation? Lawrence, do you want to maybe share a bit about this?
I think it's all on a case-by-case basis. It's not possible to say, with a broad stroke, how much MCs can a GP give, how much MC can a GP not give. Just to know that paid sick leave is up to 14 days. Anything beyond that, the employer is not obliged to pay for the MC. And if they have got any other insurance, of course, the insurance may cover it, and then the worker can still get paid. Then the question also is, I'll break it into another part. The question is how long a duration can we give per visit? B is how long of MC can we give in total? So I have seen some patients who have got a severe injury of the lower limb or the spine, and they come again and again and again. So it all depends on your assessment and what you think is the duration of MC that he's A, unable to work, B, that he will need for recovery. So remember, your first duty is the patient's best interest. So when it comes to MC, actually, the best interest principle applies. Also, the principle of the reasonable doctor. I think these are the two things that you need to keep in mind. Besides the ECEG 2016, and don't forget the handbook on the medical ethics. You got to read these two together. And if you can just keep this in mind, you'll be very safe. Over to you.
I think I want to add here that there are two factors of MC. We are talking about two factors. The patient get to rest, recover, and get paid MC. But there's a third factor from an employment perspective. Absence without medical leave can mean that the employer can terminate the employee. So you have to be very careful. There is third perspective that why is the patient wanting an MC even though he's not going to be paid? I mean, the employer can then terminate him for being absent from work without a medical leave or hospitalization leave. So that's one thing. Secondly, I just cut in shortly on the very extended medical leave request. My advice is, if the patient requires such long extended medical leave, you should refer the patient to a specialist. Don't take it on your plate. Because if my assumption is that if so long you need quite long medical leave, the condition must be more than serious. I will be quite serious. Better at least offer a referral to a specialist and document this, please.
Thank you.
I think
for
to
that-
take it
for that-
sorry.
Yeah, Prof. Sorry, just carrying on from Charles' point, I have asked occupational medicine specialist, Colonel Dr. Brian C., and he gave me the web links. I didn't have time to put it into my slide. They gave me the web links to all the big government hospitals, NHG, SingHealth, and all that, to refer to the occupational medicine clinic for cases where you think you require long MCs. So I'm talking about severe back pain and of course, industrial accidents and all that. So they, being the occupational medicine specialists, or what we call occupational physicians, the OPs are more able to handle all these sort of complex MC cases. And this is where I think GPs must work with OPs. And there are some articles overseas which shows that GPs who's got access to OP clinics feel more comfortable giving MCs. So perhaps there's one other area that we can explore, that we GPs don't work in isolation, but we work with other specialists, particularly occupational medicine specialists. Over to you. Prof. Thiru?
Now, actually, I just wanted to support what you said. I think as a general practitioner, all right, I think you produced the study that was done in the polyclinic, right? And what are the common cases that you see? And these are for short illnesses. And you would give a short duration and you then expect the patient to get better. But when we talk about the case that Sarah presented, right, where there was a twisted ankle and there was a swelling, although the X-ray was normal, there could be many other soft tissue injuries which are serious, including tear of ligaments and other things, right? And therefore, one point I want to make, I think, is really to be very firm in your diagnosis, in your assessment. How strong is your diagnosis? Secondly, the second question is, how severe is this illness? All right, and this severity, how is it affecting the patient's work? And I think if you think along those lines very clearly, you will find the answer. And I think as the question is not so much how many days can the GP give, I think when it comes to a complex case where you have a problem with the patient's illness and occupation, I agree with Charles and Lawrence. It's time to refer the patient to the specialist for a better assessment. Over to you.
Thank you so much, Prof, for lending that perspective and summing things up. In the interest of time, I'm afraid that we have come to the end of the panel discussion, and I hope that we are sorry that we are unable to answer all your questions, but we hope that we have tackled some of the key questions that has been asked by most of our participants. And
James, there's one point I thought I'll just give me 1 minute. I think the question of refusal of MC, and it has come up in the question. I think it's an important point. The patient basically has a right to refuse everything, right? Because medicine is a private matter. However, when this private matter impinges on others, then there is something that a doctor must be aware. In other words, if the patient's illness has an impact on his work that may put himself at risk if he's driving heavy machinery, or his colleagues may be at risk, or he is basically, what shall I say, be a public safety, right? Then I think you may have to exercise some form of caution. And how you are going to do that, then you have to make a decision whether you want to inform the employer, sorry, right? And whether you want to inform the employer that it is too dangerous for the patient and for his colleagues for him to continue to work. And that's a decision that you have to make.
absolutely, Prof. I think in this case,
I would just like to say that actually in some countries, the MC is given directly to the employer. I can't remember where I read it. It's given directly to the employer. And actually, employers can actually verify MCs on our government GovTech website, mc.gov.sg. It is there. So this thing about handling MC to the patient then and not to the employer, it's not watertight. Yeah. Because sometimes like for instance,
Lawrence,
sometimes
I better tell you that it's in the ethical code and guidelines. The
yes,
MC
as far as
must be given
Singapore,
to the patient.
yeah, so as far as Singapore is concerned, yeah. But like for instance, actually some pilots I see, if I'm given an MC and they refuse and they still continue to fly, that is very, very dangerous. So the company has actually told the pilots and tech crew that they cannot refuse MC. But I stand corrected by Charles, and I'm glad Charles spoke up. You still in Singapore, you have to give the MC to the patient, and then it's up to the patient to submit it. But if you feel that the MC should be given for public safety interests, then you must issue the MC. You must issue the MC.
Yeah, so I think
Thanks,
the
Charles.
important thing is to learn some negotiation skills and clarification. Why is the patient refusing the MC? All right, sometimes it could be just ignorance of facts. But I think, as I said, the line should be drawn when others are at risk by the patient continuing to go to work, then you need to take appropriate action.
Thank you so much, everyone. So that brings me to the end of the webinar. Thank you for the very engaging exchange and the panel discussion, also the Q&A. So that brings us to the end of the webinar, and I thought with all the discussion that we had, to summarize some of the points for our audience and learners here, so that we have some key points to take away from the amount of information shared and the insight shared as well. I think the first thing is that our ethical and professional duties as doctors. Medical certification is both a clinical and societal responsibility, as we've seen. There's a need to balance both beneficence, patient welfare, autonomy of the patient, and also justice and public safety. So while our duty of care is to the patient, the issuance of an MC also carries a professional, legal, occupational, and public responsibility. And of course, while we advocate for patient, MC should be issued with fairness, objectivity, honesty, integrity, and professional independence based on our sound clinical judgment. And of course, that was what Prof. Teo also mentioned as well, and also Prof. Lawrence, when you're issuing an MC, you actually shift from a role from a patient advocate to that of an independent medical examiner. So as we recall last year, we had a webinar on the doctor as a medical examiner. These are the 4 principles that should guide us whenever we do assume the examiner role. In this case, that of issuing an MC, which is to act in good faith, due diligence, act to the standard of the prudent doctor, and of course, free from perceived or actual conflict of interest. Then, of course, we, as Prof. Lawrence has mentioned, we serve as gatekeepers, like it or not, in the issuance of MC due to the Sick Role and Employment Act.
Time's up.
So we should be aware of
Please
the
exit this
implications
station
of
now.
the issue MC. It has
Tuesdays.
important
Please
implications.
remain seated for the next 1 minute.
So, it is
Do not start reading or writing yet.
apologies. So we need to, including our role in certifying the patient's temporary sick role, conferring statutory entitlement to paid sick leave, supporting employment insurance, workplace injury, and other legal claims. And of course, as we shared and we've discussed throughout this whole webinar, we can understand that it can be quite professionally complex. There's a lot of ground issues and practice issues. We need to balance our roles as patient advocates while being independent assessors. And of course, to recognize the various constraints such as time, resources, the psychosocial complexity of illness, sometimes the clinical uncertainty, and of course, our medical, legal, and professional risks, expectation from third parties, employers, and patients, and how to have a clear boundary where possible when dealing with them. And of course, we can see that there is some case law, but the legal framework is quite limited when it comes to about the standard of care for MC issuance. Remember, clear and contemporaneous documentation is essential to justify your clinical assessment and the reasons, the basis for the issuance of the MC. And that will support you both for continuity of care, professional accountability, and also medical legal defensibility. The last thing about it is that MC is a confidential information. It's enshrined in ECEG that you need to respect patient confidentiality. You do not disclose the MC information. The MC should be given only to the patient. So it should only any disclosure to further our knowledge, our judgment, and to also increase our confidence and consistency as a profession in issuing MCs. And of course, the other part, on one end, we have the sickness certification, but what about the other end about fitness for work, as they work hand in hand and they're complementary to each other in helping the patient recover. The last point is that while we've so far been talking about the doctor, in the professional role in issuing MC, but also we can see MC also has a clinical governance element to it. It's not just about the doctor, but it's also about the environment that the doctor practices in. So maybe something for us to think about is about clinical governance in MC issuance. I think some of us are clinic owners, or we work in the organizations that take care of doctors. And as such, I give a definition of clinical governance from the UK Department of Health. It is a system where healthcare organizations are accountable for continuously improving the quality of their services and safeguarding high standards of care by creating an environment where clinical excellence can flourish. And these are the elements of clinical governance as forwarded by Sakir K in the on the paper, the briefing paper about clinical governance in the UK NHS. These are some of the elements like organizational leadership, performance review, audit, risk management, research, education, learning from complaints, finding out from the user and the patient views, and use of clinical information to better improve the service. So with that, I've come to the end. I would like to invite the president, Dr. Wong, back to close the webinar. President, over to you.
Thanks very much, James. Can you hear me? I just realized my mic earlier was a bit too soft. Okay, yeah, but I'd like to thank everyone here, the distinguished speakers and the panel, for taking your time to share all your important points with us. I think I learned a lot. There's quite a lot of information that we need to digest. I think what stood out for me this afternoon was that judging from the large number of Q&A questions, it's quite clear that the issuance of medical certification is not so straightforward, right? Decisions are often involve balancing a lot of uncertainty, and it's also patient expectations, and as well as employer requirements and medical legal considerations. So it's highly contextual for every patient, right? And a patient's fitness for work just cannot be solely based on the medical diagnosis, but you have to take into account the patient's functional capacity, the patient's occupation, the workplace environment, and social circumstances. The same condition may affect different individuals in very different ways depending on the nature of the work and their personal circumstances. So I think the take-home message is that MCs should be tailored to the specific needs of each patient rather than issue according to a template or a fixed duration based on diagnosis alone. And the other side of the medical certification coin that I could hear is that the role of the employer and the HR, right? We have to be very clear that our medical decisions are not mixed up with these competing tensions, or what Prof. Teo said, right? We have to be mindful of the difference between conflict of interest and competing interests. So as doctors, we just have to stick to the principles set out in the SMC ECEG, make the medical judgment based on our interaction with the patient at that point of time. So thanks everyone for joining us this afternoon. And thank you, James, for organizing this wonderful seminar.